welcome to another edition of GRC Solutions TV. We're joined today by Heather Tropman. Heather's the Group Executive at Data, International Data and Voice at Macquarie Telecom. Thanks for joining us today.
Thank you for having me.
In our compliance forum today, we talked about data protection and information security. We mentioned that PRISM is collecting information, not just from the US, but partner countries, including Australia. What kind of laws apply to the international flow of information? And do the Mutual Legal Assistance Treaties, MLATs, apply?
Well, there is a Mutual Legal Assistance Treaty between Australia and the US. How that works is one government will make a request of the other government for information sharing, but there needs to be some form of criminal investigation or proceedings that are on foot. There's quite a high threshold. The types of cases that I'm aware of usually involve things like money laundering, where, for example, the US government might ask the Australian government to give access to bank records if they believe that the proceeds of crime are being held in another country. But it's not to be used as a fishing expedition. There's a fair amount of rigour around the process. And I contrast that with the Patriot Act, because the US Patriot Act allows the US government to gain access to information held by US companies in other countries such as Australia without the same level of judicial oversight and without the issuance of a warrant. So they can use things like national security letters, which are administrative subpoenas, to get access to that information. When it comes to the MLAT, or the Mutual Legal Assistance Treaties, it's really about one government getting access to information, getting permission to access information from another government, and that threshold around criminal proceedings and the like, and the judicial oversight and rigour that's applied to that process is quite high.
Sure, thank you. So if the US government wanted access to data held in Australia, could they invoke that MLAT?
Well, they could invoke the MLAT, but only in those limited circumstances.
Yeah.
So it's not the case that they could ask for information from the government just out of interest or to go on some sort of fishing expedition. And the other, I guess, exception to the rules, we've seen in the media lately that there's been some discussion about an agreement between Telstra and the FBI. And I believe that agreement's been leaked in the media. And so, of course, companies can contract with the US government to provide information to them, and that sits outside of the MLAT process.
Sure. A little closer to home, in our neighbourhood, we talked about the case where the New Zealand Earthquake Commission took out an injunction over a privacy breach, a leak of some claims information. What are the ramifications for employees who inadvertently leak data in that sort of situation?
Well, I think that's a tricky question, because where there's been an intention to leak data, the law is very clear, and there's certain duties around confidentiality and common law provisions that apply. When it's done inadvertently, the question becomes, should the employee be liable for any losses or ramifications of that inadvertent action? In terms of the privacy laws and laws around confidentiality, they don't specifically talk about inadvertent leaks. The common law looks at things like, was the information imparted in circumstances that denote a degree of confidentiality? Were there employment terms that dealt with the protection of certain information? Is there a contract in place and the like? So the inadvertent question is quite a tricky one.
Yes.
My view is that if information is leaked inadvertently and I was to receive that information, if there's no element of confidentiality around that email or that leak of information, and as the recipient I wasn't aware that there was any confidence around that, and I give the example of a CEO about to resign, and he accidentally sends that email to industry people rather than his HR representative.
Yes.
But I don't realise that that's sent to me inadvertently,
Yep.
or that there's any confidentiality, and there'd be nothing wrong with me sending that email on to other people completely unaware
Yes.
of the circumstances behind the scene. But it really does come down to the facts and circumstances of every case as to whether liability will flow.
Yeah, and you briefly touched on the recipient of the information and what they do with it. And I know in the forum, and we'll talk to some of the other panellists about the moral, ethical, legal angle about what the recipient does with that data.
Well, that's right. I mean, John, there's the law and what it says around common law duties of confidentiality. and then there's the moral obligations. And at the end of the day, I may well receive something, be unsure about whether it was really intended for me, be unsure about the circumstances, and be a bit perhaps cautious. It's also very different if I get an email or a phone call shortly afterwards that says, sorry, wasn't meant for you, please delete, and then what I choose to do.
Sure. Been in those sort of situations myself. So stemming from some of that, the Australian government is flagging new policies that require agencies to consider cloud hosting.
Okay.
So what kind of privacy and information security risks should people be aware of before they commit to cloud hosting?
Well, I'm aware that the federal government has taken quite a long, hard look at where to store its data. There have been task forces and committees, a number of things, and some of which Macquarie Telecom has been quite involved in those debates and in having conversations with the government. And I really think it depends on what information they're storing. So if the Department of Defence or Prime Minister and Cabinet and highly sort of sensitive data, I think they really need to understand where that data is stored. Is that data stored in Australia, subject to the national privacy principles and the laws that we enjoy here? Will it land overseas where it's subject to a different regime altogether? So understanding where data is stored, understanding the access regime, can they get the data out, back quickly? All those sorts of factors I think need to be considered and in all likelihood have been well thought through and considered by the government.
Sure, thank you. Finally, we had a nice graphic of JFK wearing some Google glasses as part of the compliance forum. Our viewers might be able to see it on some of the material that we provide. A wearable computer that interacts with the internet, takes photos and records videos. Are the current NPPs or the forthcoming APPs, the Australian privacy laws, up to the task of dealing with new international technology like this?
Well, I think it's that age-old question. John, what comes first, the technology or the law? And I think we've seen in the copyright areas that the Copyright Act was designed to protect, the publication of books and then infringements of copywriting books and traditional media.
Yes.
And it needed to be updated after technology advances, meant that we could share, digital music files, for example. And reforms came after the technological advances. And I think we'll see the same thing in the privacy sector as well. Our laws in Australia and the NPPs and the upcoming APPs are quite robust, and they provide protection for Australians, in my opinion, based on the current set of facts and circumstances that we find ourselves in today.
Sure.
These Google glasses, we're yet to see in practice what kinds of information those glasses will capture and what people will do with them. And it may be that the law needs to catch up with technology, and we'll have to watch that unfold.
Sure, yeah, I think we're constantly playing catch-up in that regard.
That's right.
Heather, I'd like to thank you very much for joining our panel today, sharing your further thoughts for our viewers, and wish you a nice day. Thank you.
Thank you for having me, John.
Thanks.